Hello, my name is Jesse Carmona, part of Team 6 Firm. We provide the best help possible to all in need with our team of experts providing excellent services and success. I'll be talking about one of our cases, providing a background, details, and results of the case showing how we, Team 6 Firm, take your needs into our hands. The case we'll be talking about is Roy Ferran versus Louisiana Secretary of State. Who was involved? The plaintiffs, Roy Ferran, Luther Scott Jr., and Louisiana State Conference of NAACP. And the defendants? Tom Shedler, the Louisiana Secretary of State, Ruth Johnson, the Secretary of Louisiana Department of Child and Family Services, and Bruce D. Greenstein, the Secretary of Louisiana Department of Health and Hospitals. Our client, Roy Ferran, and a group of individuals believed voter registration process was not in line with NVRA, having obstacles, practices that made it difficult for one to register to vote. The violations they came up against were restrictive registration deadlines, inadequate registration opportunities at state agencies, and excessive demands such as complex verification and multiple forms of identification. NVRA. The National Voter Registration Act is supposed to provide public assistance offices where voter registration services are provided, mail-in registrations, restrictions on purging such as removing registered voters, maintaining accurate voter rolls, reporting requirements showing state registration statistics, enforcement allowing individuals to sue states for noncompliance with NVRA, such as in this case, accessibility to voting registration, a 30-day deadline for states to process registration applications, and the prohibition of cross-state matching to remove voters unless certain conditions are met. Now, to introduce you one of the main points during this case that caused conflict, interrogatories. They are a set of questions posed by one party in lawsuit to the other party with the limitation of 25 per defendant. These can be filed only after a meet and confer conference is planned stating discovery planning, which is called the Rule 26F. A response to interrogatories within 30 days are needed to be met. There are two types that can be asked, either an identification interrogatory, which questions names and places, and a contention interrogatory, where a party asserts or has an intention behind the assertions. Now, the process of this case and how we dealt with it. There was a filed complaint on April 19, 2011, where the defendants failed to comply with Section 7 of the NVRA, which is Public Assistance Agencies offer voter registration services. Interrogatories took place with 15 made toward the Secretary of State and 24 to each of the other two defendants. The interrogatories made were similar, except there were 9 additional interrogatories for the defendants compared to those for the Secretary of State. These interrogatories were used to gather detailed information from the defendants regarding their compliance with NVRA, as well as identifying procedures, evaluating training and resources, collecting data, investigating complaints, examining communications and coordination, and reviewing legal actions and future plans. The defendants argued for protective orders against these interrogatories due to 3 distinct time periods of having to answer to them, such as the initial time period from January 2001 to December 31st, 2007, the interim time period January 1st, 2008 to January 11, 2011, and post notification from January 12, 2011 to the present. feeling this tripled the number of interrogatories made against them. The court ruled against this situation by saying there was an excessive number of interrogations made, but not due to the time periods, but to the discrete subparts in certain interrogatories. This means that the questioning there were multiple questions made in one where the answer was complete in the first part of the question, making the second part of the question a separate interrogatory. The protective order was granted to these interrogatories made, but if the plaintiff were to ask again having interrogatories under 25, they must answer. The relevant time period. Plaintiffs attempted to expand the scope of discovery to find patterns of violation and trends. The defendant opposed to this as their violation was brought up in 2008. The ruling was to have discovery from 2001 to the present, since it is reasonable to have questions in the 10-year gap given, allowing them to find patterns of violations. With different questions and wording for the interrogatories and rulings known, this allowed to have analysis of voter registration data to identify patterns of noncompliance, assessment of impact of noncompliance of voter turnout and election integrity, and allowed the review of state resources allocated to voter registration efforts. All this presented in court allowed us to have a successful final court decision saying that Louisiana did in fact violate NVRA and failed to offer voter registration services and required agencies to amend and ensure compliance with NVRA with monitoring over a 3-year period. This allowed our client and many others affected by this injustice to have the right once again and be allowed to register to vote without any problems. If there are any questions or comments, please submit them in the chat and we are happy to help that all are in need. Thank you.